It just, like I checked all. Is it still- I received.
All right, good morning. Welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Misty Backus, Daniel Bryant, Daniel Clayton Bryant, Tammy Crocker, Noemi Esquivel, Hannah Hampton, Louis Leha, Amber Morphus, Lucas Perry, or Peary, I'm sorry. Is it Peary? Perry. Lena Price. Lena Price. I do have a note that says, and that's a sanctions court, that she may be late. We'll recall her. Avery Tienda. Emerson Abbott. Crystal Box. Robert Campbell. Robert Baker Campbell. Randy Chavez Torres.
It was my understanding that Mr. Chavez Torres was recently released from Hunt County, but because he had personal knowledge, I'm not sure if he received notice of this hearing. I reached out to the number I had, so not able to hold with the moment.
All right, we'll recall it. Sean Davis. James Dennis. I have a note that James Dennis is incarcerated in Smith County, so we'll recall that one. Erica Ford. Erica Renee Ford. Jose Molina. Kenneth Nash. John Peace. Patrick Rowe. James Wheeler Shelton. Cause number CR 24-147-148. Mr. Manning filed a waiver of arraignment that was approved, and pretrial was set October 17th. Christopher Slow. I believe that he may be in Dallas County, so we'll recall that one as well. Andre Stewart. Patrick Ulibarri. CR 24-155, waiver of arraignment, file of Mr. Manning, pretrial set September 26th. Damon Watson. Leola Brumley. Carrie Sanders is in Wood County. Mr. Waldron is present on Zoom. I'll recall that. He can make an announcement. Taylor Chenault. Delvin Mitchell. That is cause number CR 24-103, waiver of arraignment filed and approved. Pretrial is set October 3rd. Tu Nguyen, cause number CR 24-144, waiver of arraignment filed and approved. Pretrial set October 1st. Jamie Warren. Caleb Wigington. All right, is there anyone who's present in the courtroom? I've not called your name. Your name, sir? Bryant? Oh, Daniel Bryant? Yes, sir. You were number 2 on the docket, and I'd called your name. Were you late?
No.
So were you late? Just tell me you were late. All right, thank you. All All right, I've marked you down as present, Mr. Bryant. All right, we have any counsel that's ready? Ready?
Yes, sir.
Who are you ready on? Manning's here. All right, cause number CR 24-121, State versus Damon Scott Watson. Where's Mr. Watson at? Come on up. No, 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 no. No, no, no. That's there for a reason. All right, Mr. Watson is set for a pretrial. Go ahead.
I don't like necessary motions. I don't need to. I want to see if we can work something out with the state. So the state and I have exchanged cards. We're going to try and get together very quickly to figure out if this is something that's all we're going to have to try. So if it's possible, we could try to push this so we could get a continuance on the pre-trial motions and kind of see where we are.
What are you anticipating on pretrial motions?
Well,
Suppressions? Well, obviously, but
say our use back of motion.
I mean, are you anticipating a motion to quash, motion to suppress something that's going to require an evidentiary hearing?
Potentially, legal argument for the case. Potentially, we have an argument that the obstruction of retaliation doesn't apply with the flow of the case. You can't threaten a witness on a case that's passed and done. So that's the argument. So it wouldn't, I don't think that would necessarily require some evidence. It would be more argument if it comes to that.
Okay, but you haven't filed any pretrial motions 7 days prior to today's setting.
That's
And is there any reason that you didn't do that? Meaning, have you received all the discoveries, or any reason you couldn't have already filed those motions, whether you needed a hearing or not?
no. I've had judges start looking through motions on a case that ultimately gets resolved. So I kind of quit filing quickly and trying to see if we could work something out with the state to avoid an eager judge from wasting time on reading motions and prepping answers on a case that isn't in trial. So I'm trying to figure out it's a chicken.
Sure. And I appreciate that. And I'll just tell you how I do it. We have arraignment, then we have a pretrial setting. The code says if you have pretrial issues, you got to file you're aware, you got to file your motion 7 days prior. Absent a good reason for failing to do that, then we move on to docket call. So what I expect attorneys to do is, if you anticipate that you're going to need an argument or an evidentiary hearing, that you file a motion and then just tell me, I don't need a hearing at this time. I'm trying to work it out with the state. If I can't work it out, I'll ask for a hearing. So I'm going to go ahead and set you for one additional pretrial motion, but I expect you to go ahead and file all your motions, whether you want a hearing or not, so that it can be preserved in the record. And then on that day, you can tell me, okay, looks like we are going to need a hearing or we're not. And then we'll move on to docket call. And then between pretrial and docket call will be the opportunity for you to work with the state, make your best offers, counter offers, and do all that. And if you need the hearing, then we'll set up for evidentiary hearing.
Thank you.
All right, let's look at your calendar. Today is the 15th. Are you available on September 24th? All right, court's going to set Mr. Watson for additional pretrial on September 24th. That'll be at 9 a.m. And Mr. Watson needs to sign that notice of appearance, and then the yellow copy stays with him. White copy will stay here. And then it's come to my attention that there's a warrant for Mr. Watson's arrest for release of surety.
What?
Release of surety. Your bondsman went off your bond.
But
I don't know. I don't know. So you're going to go into custody at this time. Ms. McBride can reach out to your bondsman.
Hey, can you give her the keys?
Yeah, they'll help you. They'll help you. And Deputy Martinez, if you'll just, you've already confirmed that warrant with the sheriff's office, right?
Yes.
Okay. All right. And if you need to see that warrant or whatever, you can see Deputy Martinez. He has a copy of it.
Okay. Thank you.
You're
Yeah,
welcome.
follow.
Yes, absolutely. All right. I'm assuming Mr. Manning's in the hallway or somewhere working, and Mr. White as well. Ms. Escobar. All right, this is a sanctions court hearing, cause number CR 21286. Let's see, Ms. Escobar, you did everything you were supposed to do. You made your payments, you did your 22 hours community service. So I'm going to reset you for another sanctions court. Remember, you're set to expire in January. The probation officers have indicated that you're going to need to increase some of your payments and your community service if you want to expire on time in January. Okay, so what I'm going to give you is an increased payment to probation, payment to court costs, and increased community service. We talked about this last time. We're trying to get you caught up. So just know this, as long as you're making a good faith effort and you're trying to get it done, if that time comes and you haven't completed everything, we can extend you. It's just going to cost you more time and more money. But if you can get everything paid off and you're only 2 months into an extension, I don't mind letting you off if you're in compliance. Okay. So understanding that these are increased, if you're unable to do it, but you get as close as you can, I'm not going to hold it against you. Make sense? But just know when January comes, if you don't have it done, we're going to have to extend you. Okay. All right. So, if you want to expire by January, you're going to have to pay $245 to probation. Okay. That was up from 200. $425 on your court collections. That's another $75. Okay. And then you'll need 27 hours of community service. Okay. And so I want to do, to keep you motivated and keep you incentivized, I want to do that same 1 day in jail for each one of those. Now, if you're close, I'm not going to put you in jail, right? If you bring me 22 hours of community service, I'm not going to put you in jail. I'm just going to be honest with you. Okay. But I want you to strive to expire on time. Makes sense? Okay. And let's see, today's the 15th. Let's come back on the 24th, September 24th. Actually, let me change that. Let's do October 1st. October 1st. Any questions about what we're doing? Okay. Thank you. Let me ask you a question. Amber Morpus. All right. Amber, this is sanctions court hearing. Last time in court, I ordered you to pay 65 to probation. You did that. I ordered you to do $50 to court collections. You did that. And then 25 hours community service. Probation department has provided me with a printout of what you turned in. But the problem is what? No one knows where is this at that you did the what? Rodeo grounds, where at? And who is Alex? Is it Alex Care?
There.
Do we know if that's been approved? All right, so let me see. So this was in July. But we don't know that any of these have been verified, and that means that they have not been credited towards her at all. So we'll need to do that, right? Okay. All right, Ms. Morpheus, I'm gonna order you back on October 1st, 65 to probation, 50 to courts, 25 hours community service. And who's the best person to contact at the rodeo grounds to confirm these things? Do you have a contact number for that person? All right, I want you to call in and give that to your probation officer. And you said Brian, well, you know Brian's last name? Okay, so 25 hours community service, 50 to courts, 60 to probation. 65, sorry, 65 to probation, 50 to court collections, 25 hours community service on October 1st. Mr. Manning, Mr. Schmidt, either one of you ready? Who you ready on? Say again. Brumley. All right, this is cause number CR 24-129, State versus Leola Autry Brumley for arraignment. Go ahead, Mr. Schmidt. Okay. Does she understand what she's charged with? All right, the court finds that Ms. Brumley has waived the formal requirements of arraignment. The court will enter her plea of not guilty into the record. Is there any motion by the state?
Yes, Your Honor, statements submitted. Indictment to reflect, Ms. Jackson's, current class.
And that's Jackson, common spelling, Jackson. Any objection? All right, there being no objection, the court grants the state's oral motion to amend the indictment to correct the last name of the defendant. The court will strike Brumley and enter Jackson into the indictment. And the court sets Ms. Brumley for pretrial hearing on October 15th at 9 a.m. And Ms. Jackson, have you met with the pretrial release officer yet, Mr. West? You have? All right, good. All right. So if you've already met with Mr. West, then once you sign and get the yellow sheet, you're free to go. Is that all you have, Mr. Schmidt? Mr. Manning, you ready? Who would you like first?
We can start with Mr. Luke Perry.
Mr. Perry? This is cause number CR 24-145, State versus Lucas Gareth Perry for arraignment. Court has found that Mr. Perry is indigent for purposes of the Sixth Amendment, has appointed the Honorable Jonathan Manning to represent Mr. Perry. Mr. Manning, do you have a copy of the indictment? Are you ready to go forward?
I do, Judge, copy of the indictment. His name is spelled correctly, indigent, charge against him. And his plea is not guilty at this time. We request to be set on a pretrial docket.
All right, court finding that Mr. Perry has waived the formal requirements of arraignment. The court does enter his plea of not guilty into the record and sets Mr. Perry for pretrial hearing. Are you available October 17th? All right, court sets Mr. Perry October 17th at 9 a.m. He's excused. Who'd you like next?
Next, we're ready on Mr. Emerson Abbott.
Emerson Abbott. This is cause number CR 24-88. Mr. Abbott's case was set for pretrial, I believe.
Yes, the quick group each say, I'm sorry. We were requesting we set for a docket call on this case. We are in the process of negotiation with the close. That's when they will be able to take care of on.
All right, court finds that there are no contested pretrial motions. We'll set this matter for a docket call. We're gonna do Thursday. I do have October 3rd. Let me see, October 3rd. Are you available the first week of October, October 3rd? All right, court sets Mr. Abbott for docket call October 3rd at 9 a.m. Mr. Abbott, I do have a note that says that you're delinquent on your pretrial release fees.
I paid, 150 yesterday.
You did? Okay. All right, thank you, sir. Yes, you're excused.
There's next ready on Sean Davis.
Mr. Davis. Cause number CR 23-95, CR 23-207, 208, and 209. I believe that we're set on status. Go ahead.
Yes, Judge, we have requested a court appointed expert in this case, and Mr. Davis has provided me with a copy of his monthly budget, as well as copies of his pay stubs the last couple of weeks. And I was gonna see if we can have a full hearing, or if we want to submit those to the court electronically, the court make a decision on the sanctions.
Yeah, if you'll just submit that to the court electronically, then the court can review that. And then if I have any questions, I can contact you.
I will update the court that I have spoken to a couple different forensic experts in this field. And right now, they're going about $10,000. So I don't know if the court is finds that Mr. Davis indigent or part of it.
Yes, sir. I understand. Yeah, if you'll just submit that information along with Mr. Davis's financials, and the court will review it for appointment purposes.
I would request that we set on the status for the expert thing, possibly retrial.
All right, court sets Mr. Davis for Thursday, October 3rd for status. And the court will also go ahead and set that for, did you say pretrial?
Yes.
We'll also set that matter for pretrial on that same date. Yes, Mr. Davis, free to go. Who'd you like next?
We would like to take Mr. Campbell.
Is Mr. Campbell here?
I don't think so. I just might put in that motion. I showed it on person with age support.
This is cause number CR 19-108, State versus Robert Baker Campbell. And Mr. Campbell's name was called earlier, is not here. Any announcements, Mr. Manning?
Judge, if I may have some time, I'll reach out to them this morning again.
All right. Court's, in transparency, the court's gonna have his name called here at the conclusion of the docket, and we'll issue a NISI if he's not present.
Next, we need to do a reset for Mr. Dennis.
Yes, cause number CR 24130 and CR 24131, State versus James Dwayne Dennis. Mr. Dennis, is set for arraignment today. Court confirmed that he is in Smith County custody. I'm not sure any more details on that. So let's reset Mr. Dennis for arraignment and status of custody to October 1st.
October,
I'm sorry, October 3rd at 9 a.m.
the next one on Mr. Kenneth Nash.
Kenneth Ray Nash, CR 2271. All right, I believe we're set for pretrial.
Yes, Judge. There were some issues with Mr. Nash's discovery. He came into my office a week or two ago. We were able to sort it out. Mr. Nash came this morning and they able to review the discovery. However, we still have to have access to the forensic interview. I viewed a forensic interview that was associated with this case, but it was not Mr. Nash's case. It was a different interview. So I believe the DA's office is still looking to find that interview. We request either to be set on additional pretrial or we request if we are set for docket call, that would be allowed to file a pretrial motion that may be necessary based off of the information provided.
We'll go ahead and set Mr. Nash for another pretrial October 3rd. And Mr. Hartwell, you said that the state is working on that.
Yes, sir. We'll work on getting those correct. Forensic interview.
All right. And Mr. Manning, my notes reflect that Mr. Nash is delinquent on his pretrial release.
Yes, sir. Mr. Nash, apprised me of that situation earlier. He said that he has switched over banks and in doing so, the part that he did working. My understanding is he is or has paid that in full today. We will get
How much did you pay?
I'll pay it in full today, but I just didn't know pay.
How much?
Based on $100, see what I had in my account.
Okay. So you'll pay 100 today? All right. All right. Once he gets his notice of appearance, free to go. John David Pease, CR 24106. Sure that we were set pre-trial competency evaluation, is that correct?
Yes, sir. We received Dr. report, and at this point in time, we are not, I don't believe we're going to get test findings. We would request to be set on Dr. Collins' case. I have gone over the discovery with Mr. Peace, and I believe we have the discovery.
All right, then the court sets Mr. Pease for docket call October 3rd at 9 a.m. Mr. Pease, I show that you're delinquent on your pretrial release fees. Have you made any payments?
Last time I took last time I actually used, but I just filled out this paper form that I would $100.
All right, you're gonna do that today? So you'll pay it by Monday? When do you think you can have it paid? You said a couple days. When do you think you can have it paid? In the next week, so by Friday of next week. So that's the 24th
And there's just,
or 23rd.
people call us. Due to medical issues. And other work. So, I have discussed with them the requirements of the pre-trial conditions. And he is aware.
All right. All right, and Mr. Pease, if you can't pay all of it, just make a substantial effort so that we don't run up a big balance. All right, that way they're not supervising you for free.
I'm ready on Mr. Patrick Rowe.
Patrick Ray Rowe, CR 23, 116 and 117. All right, so Mr. Rowe is set for docket call.
Yes, Coach. Mr. Rowe and I have provided the district attorney's office with some mitigating exculpatory evidence that we wish to investigate. My understanding is that this time we have been unable to investigate that, so we request additional documents.
That's correct, Your Honor. I'm aware of the information. I haven't been directly involved with the but I am aware of the information. I will provide at least one final docket call to give us an opportunity to follow.
All right, then the court will grant a request and set a final docket call on October 3rd at 9 a.m.
And Judge, I would report that Mr. Rowe was showing that he did pay $370.62 for his bill. Appreciate all these fees done today.
All right, thank you, sir. Would you do me a favor? Will you go see Mr. Bryant and ask him if he's going to request court appointed attorney? Who else ready on?
Do we need to do reset and register slow?
Yes, cause number CR 24-149, State versus Christopher Paul Slow. Set for arraignment today. Court finds that he is in custody in Dallas County. There may be a variation on his name. I think they have him booked in as SLOAGH. I don't know, just something to mark down, and we'll consider once we get him here to make sure his name is spelled correctly. But all right, let's reset Mr. Slow for arraignment and status of custody on October 3rd. Let's go ahead and call Erica Ford. Is Erica Ford here? Cause number CR 2418. Court finds that Ms. Ford is not present. Do you have any information, Mr. Manning?
Judge, I know that I had reached out. uh, Once I got notice of her second, I don't believe that she responds. Well, the board, she is on personal bond. I don't have to.
Okay. All right, and are you doing pleas on Miss Fox and Mr. Molina and Mr. Stewart? All right, do you need time to go over those?
Yeah,
All right, go ahead. You got anything else that you need to announce at this time?
I was just taking more on this Hampton, if you want to reset her now.
Okay, sure. Miss Hampton, cause number CR 2390. Court finds that Miss Hampton has requested a court-appointed attorney. The court finds her indigent for the purposes of the Sixth Amendment, has appointed Jonathan Manning to represent her. Have you had an opportunity to go over the motion to revoke with your client?
Judge, I have no. Do it, let's go ahead and get her reset, stop it, and discuss this with her outside.
All right, the court will set Miss Hampton for do you want a status before we set it on a contested docket?
You know, let's-
All right, court will set Miss Hampton. We're gonna go ahead and set her for two settings. We're gonna set her just for an announcement on the motion to revoke on October 3rd. And if there is no resolution to the case, then we'll also set it on the contested docket, October 31st.
October when?
31st. And Miss Hampton, once you sign, I want you to come over here and meet with the probation department. There's a request to have you UA'd due to non-reporting and absconding. Yes, yes, sir. Mr. White, you ready? Who would you like to call? Taylor Evans Chenault, CR 2493. All right, Mr. Chenault set for pretrial. How much time do you need, Mr. White? We could do week after next, we could do the 27th. Sure, yeah, absolutely. That's our evidentiary docket, so I'm sure we could squeeze that in. All right, court sets Mr. Chenault for plea, October 29th. Is that a morning plea, Mr. White?
August 29th.
Yes, but is that a morning plea or an afternoon plea?
That's.
Morning plea. All right. Court sets it October 29th at. I'm sorry. Now I know why Mr. White was looking at me like, are you sure you want October? And I said, yeah, I want October. August. I'm sorry, Mr. White. August. Just throw something. All right. Just throw something up on the desk and go, hey, what are you talking about? I've been setting a bunch of stuff for October, so I just set Mr. Manning for October. So, but I think Mr. White was just going to take it. He just told Mr. Chanel, hey, looks like we're coming back in October. All right, you're free to go. Who else? Yes, Jamie Taylor Warren, cause number CR 24120. All right, Mr. Warren set for pretrial.
Yes, sir.
Yes, please. All right, after a discussion with counsel off the record, the court will set Mr. Warren for a status. We'll set for pretrial and status on November 12th.
Yes, sir.
2024 at 9 a.m. Ready to go?
And you got this reading here, but I can add it.
Okay. All right, Mr. Hartwell, I'm going to bring Mr. Waldron in on Zoom. I think both of his clients are in, one's in Wood County, I think, and there's another one also. Good morning, Mr. Waldron.
Good morning, Judge.
Sorry to keep you waiting. This
No, I
is,
wasn't.
I'm gonna go ahead and call Carrie Lynn Sanders, cause number CR 22-392. And we're set for pretrial. Some understanding that Mr. Sanders is in custody in Wood County and that you were gonna make an announcement.
That's correct, Judge. Mr. Sanders is in custody in Wood County. I've been speaking with both Ms. Curry and Brandon Body in Wood County about a joint resolution of those cases. I think we're pretty close. I think if we roll this to the next docket a month from now, we'll have hopefully a plea to present to the court.
Okay. How long do you need? You think 30 days or so?
30 days will be fine. I've just got to get a commitment from Mr. Body in Wood County, and I think I can get that done in 30 days.
Tell you what, how about we bump it out a little bit farther? How about October 1st?
That'll be fine.
Okay. All right. Court sets Mr. Sanders for pretrial and status October 1st.
And Judge, I
you,
believe bond signed a surety off bond or presented that to the court on his Van Zandt County bond, so that should hit your desk.
okay. And so we expect him to be in custody then on October 1st.
Correct.
All right. So we'll go ahead and we'll set this at 1:30 then on the jail docket
Okay.
that day. And I'm trying to think. I'm not sure if I saw it on Mr. Sanders' case. I may have. If it's one that came in yesterday, I think I had to deny it because they did a 1719 instead of a 1716, meaning that the bondsman didn't send the affidavit to the sheriff to say I'm surrendering due to incarceration. And then the sheriff has to do their part, attach the detainer and all that. They just asked for a warrant to be arrested. And I think I denied it. So
Okay.
you may touch base with the bondsman. I wrote denied and I wrote why, but I think I just put non-compliance with 1716 because it needs to go through the channels of the sheriff's rather than just getting an arrest warrant issued. They should file that they're surrendering due to incarceration. I'm telling you, you know what they've got to do. If you'll just let them know, then get that sent over and we'll get that bond off.
Sounds good. I'll make sure I get that done. It's anticipated, just so the court knows, that Wood County's considering dismissing their charges for a plea in your court. So that's what our plan is.
Okay, very well, very well. Now, was Mr. Sanders the only one that you had on today's docket?
Mr. Edwards may not be on there anymore since he was taken to federal custody. He had been in federal custody and they took him off for service of his sentence. I anticipate him being back within the next couple of months because he's been in jail continuously since, I believe, May of last year on a 21-month sentence, maybe federal. I've been talking with Ms. Curry. I think we have that one worked out as far as a plea, but when he gets back, we'll address it.
Okay, yeah, and I don't see him on the docket today, so you're probably right about that. So, but I appreciate the info nevertheless.
Yes, sir. Not
All
a
right,
problem.
well, I'll let you get back to pursuing justice over there in Gregg County.
All right. Thank you, sir.
You bet. Have a good day. Mr. Tienda, come on up. All right, let's see. This is Sanctions Court hearing. All right, let's see. I ordered you to do 25 hours community service. Says that you worked 26 hours, but it got applied to your Kaufman County case by your Hunt County officer. So that is what it is. Ordered you to pay 125. It says you paid 300. All right, good job. Good job. All right, so what I'm going to do is I'm going to reset you for October 1st, and I need you to do 125 or more. All right, minimum 125 to probation and 25 hours community service. Okay. So if you're the community service that you're doing, if you need it applied here, you need to make sure that they apply it here and not somewhere else. I understand that you got two cases going on. Just make sure that you're not sending everything over there, because then you're going to get way behind over here. Okay. All right. So we'll see you back on the 1st. Deputy Martinez has got this notice for you. You have any questions? Okay. Ms. Crocker. All right, this is also a sanctions court hearing. All right, Ms. Crocker, let's see. You complied with your court orders. You paid 90 to probation. You paid 100 towards your restitution. So I'm gonna tell me you laid out that plan for me a while back, right? How do you feel like that's going, your plan?
It's slow right now, but I'm trying to get it going better.
Okay.
Just sound right over COVID last, I was out for 2 weeks because I had COVID.
Okay. All right. Well, I'm gonna have you come back on the 1st, and I need 90 to probation and 100 towards your restitution. Okay.
Try to pay more than that.
Okay. I'm sure your victim would appreciate it. You're welcome. Mr. Leha? All right, let's see, Louise. Looks like you paid your probation fee. You paid it late, but you paid it. You paid it yesterday, right? And you did your 30 hours community service. You did 80. Well, they're putting that they just say that you complied. So that's good. Where'd you do 80 hours at? Okay, good. Good. Well, you keep on. You don't have much to go. Yeah. It's kind of good to see the end of the road, isn't it? Yeah, get that behind you. One less thing hanging over your head. So all right, very, very good. You plan on knocking out the rest of you'll be completed by next time. So if I bring you back on October 1st, you'll do the remainder. So you think that you have how much left? It looks like you have 20 hours. It's my records are showing something a little bit different. I don't know. Say again. No, I mean, it doesn't tell me how many you did. It just says that you complied. It's showing today's record is showing that you've worked 343 and a half hours out of 400. So that would be, 56 and a half left. But I don't know if that's updated. I don't know if that depends on when you turned it in. All right, you might want to talk with your probation officer just to make sure that you are on the same page. But this is what I'm going to say. I'm going to say on 10/1, $60 to probation. Okay. And I'm just going to say 30 hours community service. If you only have 20 hours left, then do whatever's left. 20, 25, whatever. I'm gonna say minimum 30. If you still have 56 to go, 30. Okay. Okay, that would be good. No court costs. No, he's paid for all court costs. Did I set Amber Marcus for October 1st?
Yes.
Okay. Ms. Backus? All right, this is also a sanctions court hearing. All right, Misty, let's see. You came up a little bit short on your probation fees. I ordered 65. You paid 50 yesterday. I'm not going to harp on that too much. Ordered you to pay 150 to court collections. You paid, I think you paid 50 on that. And I ordered 24 hours community service. It looks like you did 15. What happened on that one? Why did you come up short on community service?
And then my alternator went out, so I had to get a new alternator, so it kind of conflicted with everything.
What did your husband go to jail for? Of this month? Like 2 days ago, 3 days ago? Oh, July. What for? Here in Van Zandt County? Don't get wrapped up in that. Do you know? Let's see. It looks like it also says that you didn't make your weekly counseling once a month. Well, it says you failed to comply. It said you didn't make you didn't do your counseling for that one time. When did you go to counseling last? What y'all talk about in counseling?
They wrote things on, do things on myself.
Yeah, that's real life stuff you got to be talking about, huh? All right, I'm gonna bring you back on October 1st. Remember, you're getting close to being off probation. April of next year, that's pretty quick. It doesn't seem like it, but it's very quick. So just know that when we're setting this stuff, we're trying to get you paid off and your community service done in time to where you can get the government out of your life. All right. For every month that you don't comply, that just creates next month to have a bigger bill you got to pay, you know? So yeah, better start doing as much as you can so that you don't end up getting extended, which is going to cost you more time, more money. It gives you an opportunity also to end up in jail for if you relapse or do anything like that. All right. You've been doing this for a long time. You understand, right? All right. So this is what we're gonna shoot for on October 1st. 65 to probation, 115 to court collections, 24 hours community service, and stay in your monthly counseling. And try to get that done the week before October 1st. Okay. Thanks for the note, the updated note. I appreciate that. Why are you breaking it? Bad at it? Who's it? Yes. You want to get,
Stay. You know, they probably not do that. I was going to trial. Even with that, I'm very grateful to you. You take a chance. And, you know, I will not let you down.
How old are you? 26. Still a young man, but a man nonetheless, correct? And so all I can do is hope that this was a youthful indiscretion, a decision that you made because of immaturity and not really thinking about as Mr. Wyatt has aptly put it, the gravity of the situation that you could be looking at. Looks like you could be facing up to 10 years in prison. And so, yeah, if I were you, I'd be very grateful for Mr. Hartwell and his office for them extending that, and Mr. White for his work in convincing them to do that. Because you're right, they don't have to do that. They could say, "Yeah, we gave you your opportunity. This is not baseball. We're not playing three strikes," and could just move you on in here and make Mr. White have to try to defend you to the best of his ability based on what you give him. And so, yeah, you are afforded a second chance today. I've approved it, but I hope that you heed the warning, because you have an opportunity to get all of this behind you in a way that's not going to affect your future. If you want to throw that away and you end up being convicted of this offense or having to be put on deferred adjudication, then it only gets worse from there on out. And that's something that people that have been in your shoes, that have thrown it all away, wish today that they could have to do over again. Because once you're convicted of something, or once you have that on your record, it's going to stay and haunt you, for the rest of your life. All right. And so, Mr. Bryant, can I ask you to say something? I see you shaking your head back there. Am I speaking truth? Am I speaking truth? Yeah, Mr. Bryant, what would you say along those lines?
This is. I had shot, this place, I'll make you one. So, you know, this, we got a bid for it, you can see, I know we got some already ready. Wait. This. With a, yeah, we're thinking of the estimate there.
And you've been down that path, Mr. Bryant? All right. So, Mr. Wigington, thank you, sir. I do appreciate you. I do appreciate you. So, Mr. Wigington, you heard it from Mr. Hartwell, from Mr. White, from me, and from Mr. Bryant. All right. So you can't say that in the future, if you screw up, you can't say, well, "Hey, I didn't know," or "I didn't have warnings." Okay. So I'm giving you the lecture now because I'm not putting you in jail. Really. I'm not revoking you. I'm not putting you to trial. Yeah, you're going to go do some jail time, but it's to try to wipe away that slate and get a new slate. Okay. All right. Court has approved the amendment to the pretrial intervention contract. Mr. Wigington, come over here and see Ms. Burns, and they'll get you a copy of that, and then you'll be free to go. Mr. Manning, making progress. Okay. Oh, he was. Okay. Yeah, we talked about it, and he told me. I knew you had told me, but I was like, I was thinking in the morning. Yeah, I can't remember what we talked about, but I guess we'll just reset that out. I don't need him to appear back to Zoom this afternoon. We can just reset it.
Thanks, other guy that reset, what did we reset? October 30th.
Yeah, we'll just do Ronald Jack Edwards the same.
What am I gonna do back?
All right, court calls cause number CR 24-92, State of Texas versus Daniel Clayton Bryant. Court has found Mr. Bryant to be indigent for purposes of the Sixth Amendment, has appointed Honorable Jonathan Manning as counsel. Mr. Manning, have you an opportunity to go over the indictment with Mr. Bryant?
Yes, sir. We have under the amendment, his name is spelled correctly. Also talked to him about there being AKA. We've discussed that as well as the rate of punishment. Please not guilty of people that we said on the pre-trial.
All right, court finds that Mr. Bryant, having waived the formal requirements of arraignment, enters his plea of not guilty into the record and sets this matter for pretrial hearing on October 3rd at 9 a.m. And Mr. Bryant, you were arrested outside of Van Zandt County, correct? Because of that, the Van Zandt County Justice Center does not have your fingerprints to report to the state, and they're required to do that. So I've tendered an order to Mr. Manning. I need you to take that order with your ID, and when you leave court, I need you to go out to the Van Zandt County Jail, which is west on Highway 64, like you're going back towards Dallas, and go in there and present that to them. They need to take you in and just get your fingerprint so they can report it to the state. And then they're not going to change you out or hold you or anything of that nature. They're just going to get those. Just know that it may take a few minutes if they're behind or whatever, but that's something that has to be reported to the state. So if you'll get that taken care of, I appreciate it. Mr. Manning, when you weren't in here, Mr. Bryan assisted the court. I was trying to give some information to a young man on a amendment to a pretrial intervention contract with Mr. White, Mr. Hartwell. So we were trying to speak to him about, future decisions and where it may land him. And while I was doing that, Mr. Bryan, I could see him, he was in the back and he was seemed to be affirmatively agreeing with the court on the things that I was telling. And so I did call out to Mr. Bryan and asked him if he wouldn't mind saying something. And so I just want to let you know your client did bring a little goodwill with the court, and that he spoke some truth to this young man and told him about some things that could be in his future if he continues to go down that path. So just wanted to let you know that that goodwill does exist there.
Excellent.
All right.
I will explain to your process, maybe the excuse.
Yes, free to go. We'll see you back October 3rd. All right. Ms. Price. All right, this is a sanctions court hearing. So Ms. Price, I understand you had some car troubles this morning.
Sorry, it's still sitting on the road, but my friend of mine came to pick me up to make sure I got here.
Good. All right. Well, sorry that happened to you. I appreciate you being here. It's good to have friends, isn't it?
Yes, it is.
Yeah.
I said, please, if you can't come get me, don't worry about the car now. I just need to get support because I'm trying to stay do the right thing. He said, you know what, that first, let's go.
All right. Good. All right. Well, so sorry that happened to you and try to get you out of here. You can go back and deal with that. Let's see. Last time you were in sanctions court, we talked about some things. Ordered you to pay 70 to probation. Looks like you did get that paid. You paid 65 to collections. You did your 10 hours community service. The only thing that we're lacking is that you were going to provide some information to your probation officer about the time that your dad was in jail. I'm sorry, that your dad was in the hospital. You'd missed sanctions court, I think, back in June, and you'd indicated it was because your dad was in the hospital. So we were just looking for confirmation of that. Did you not?
He had the papers on it, but he didn't know, I didn't know what month. He had it set there, what month it was. And I was supposed to provide for him because the one I missed. And he said, like, what dates? I said, it just some, the paper showing that month that you were in hospital. And he's got it. I just got, I'm gonna mail it to her today. He mailed to her today. Yes, Mr. today.
All right, I'm gonna give you one more opportunity to do that. Okay, if you don't get that done, then I have to go back in time and I have to say, okay, Lena missed court in June and there was not a good reason.
Oh, no, I'll do it today for sure, and as soon as I get my, go back and get stuff out the paper on my car, and then I'm going to my dad's, I'm gonna do it today, because I got my email this morning.
All right, the sooner the better.
I also have a question, sir.
Go ahead.
My other house, like on hospice, and she had, what do you call it, when they stop breathing at home, and they had to have ambulance, and she was on life support. With me coming to work, what would I have to do to hurry up and get off of here from some of the safety sports, so I can, because she's bedridden, and I just want me to find somebody to stay with her while.
Sure. So what I'm looking for in sanctions court is several consecutive months of compliance without having to ask for things and without you coming up short on things. So I need to see several months linked together. Usually for me, it's around 6 months. Once I've seen somebody 6 times and I've gotten them back on the right track and there's no problems, then I'll let them out of sanctions court. So I'm just looking for consistency. That's the short answer. It's not a, maybe a sufficient answer for you, but I'm looking for consistency, right? On-time payments, community service done, no problems. This is what I'd ask you to do. You've done it month after month after month after month. Once I see that pattern, then I say, okay, you're good enough to go do it on your own. But that's where we're at, right? So like asking for the hospital stuff and things of that nature, those are what go into consistency. Okay. So I'm gonna bring you back on October 1st, all right? And we'll do $60 to probation. We'll do $60 to court collections. And these are the amounts that you have to pay every month in order to expire on time in May of 26. And 10.
Try to update it online, it still shows $60 on there. So, and they're trying to update it to 70 where I can pay them. Because it won't let me pay 60 and then go back in and pay.
Okay. Okay. Well, I'll let y'all get that worked out. I'm not upset about it or anything. So I'll let y'all figure that out. Okay. 10 hours community service. And I need that proof of what you said was the reason that you missed that sanctions court. Okay. So the hospital letter.
I'll get that done. Thing done, the paper sheet today.
Well, if not today, just at least before you come back to court.
I appreciate it, sir.
You're welcome. Good luck.
Thank you. Have a good day.
You too. Mr. Randy, you ready? Who are you ready on? Miss Box, if you'll come forward, please. All right, this is cause number CR 2441, CR 24160, State versus Crystal Lynn Box. Are we doing a plea today, Mr. Randy?
Yes, sir.
All right, do we have paperwork?
I'm sorry.
It's okay. All right, Ms. Box, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand. Is your name Crystal Lynn Box? And Ms. Box, are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with a mental condition? In this case, you're represented by your attorney, Mr. Manning. Are you pleased with Mr. Manning and the work he's done for you? Do you have any questions about any of the paperwork that you've signed as part of your plea agreement today? Do you have any questions before we go further? Mr. Manning, do you believe Ms. Box to be competent? And if so, do you believe that she understands her rights and that she's entering into this plea intentionally, knowingly, and voluntarily?
I do think very confident. We've discussed possible offenses in this case, as well as the facts of both cases. And I believe she is entering into this plea intentionally, knowingly.
Thank you, Mr. Manning. All right, Ms. Box, in cause number CR 24-160, I see that you are charged with an offense of assault causes bodily injury of a family member, a Class A misdemeanor. If you were to be convicted of that offense, the potential range of punishment is confinement in the county jail for a period not to exceed 365 days and a possible fine not to exceed $4,000. I see the plea agreement in your case is that upon your plea of guilty, the state's recommending that the court consider the evidence, convict you of the offense, and assess your punishment at 1 year confinement in the county jail. But they're recommending that the court suspend that sentence and place you on community supervision or probation for 2 years, and also ordering you to pay a $500 fine, $270 in court costs, and $535 in reimbursement fees to Van Zandt County. As part of the plea agreement, the state's indicating that they want the court to dismiss your tampering, fabricating physical evidence, third-degree felony, which is cause number CR 2441. Ms. Box, is that your understanding of the plea agreement? And that's what you're asking the court to approve? All right, then, Ms. Box, understanding those things, how do you plead to the Class A misdemeanor assault causes bodily injury of a family member? Are you pleading guilty to that crime because you are in fact guilty of committing that crime? And has anyone threatened, forced, or pressured you to plead guilty? Court will accept the defendant's plea of guilt at this time. Mr. Manning, any objection to the stipulation of evidence?
No, since one has all.
All right, that is admitted, and the court does take judicial notice of the defendant's judicial confession. Anything further from state?
Your Honor, I'm trying to quote the case now. I'm sure that the compliance by the handling.
Sure, go ahead.
The case is not.
You said it's not pulling up, yeah.
Right.
Okay.
And I'm pretty large compliance. And that would change that.
All right, thank you, Mr. Harwell. Anything further from the defense?
None.
All right, court's going to review the evidence, and I think the evidence is just the complaint information. Is that correct? Okay. I don't believe that this is marked. I'm gonna go ahead and mark this as stipulation of evidence. Is this? Oh, there it is. All right, upon the court's review of the evidence, court finds that there is sufficient evidence to convict the defendant of this offense. The court will follow the plea agreement reached between the state and the defense. Court hereby convicts Crystal Lynn Box of assault causes bodily injury of a family member, a Class A misdemeanor. The court assesses her punishment at 365 days or 1 year in the Van Zandt County Jail. The court today suspends that sentence and places Ms. Box on 2 years of community supervision. The court orders her to pay a $500 fine, $270 court costs, $535 in reimbursement fees. All right, Ms. Box. I hereby remand you to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted with Deputy Martinez, and then the probation officers will give you more information. Thanks, sir. Yes.
They're all going to be identical, but they're from one things.
Okay, thank you. All right, Mr. Stewart. All right, court calls cause numbers CR 24-114 and 115 and 116 and 117 and 118. State versus Andre Stewart Jr. Mr. Stewart, sir, if you'll raise your right hand, I'll place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand. Mr. Stewart, are you a United States citizen who reads, writes, and speaks English? And have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Manning. Are you pleased with Mr. Manning and the work that he's done for you? Do you understand everything that you've read and signed that's part of your plea agreement? Do you have any questions before we go further? All right, Mr. Manning, do you believe Mr. Stewart to be competent today? And if so, do you believe that he understands his rights and that he's entering into these pleas intentionally, knowingly, and voluntarily?
I do, Judge, whether he is competent. Additionally, I believe he is known and voluntarily.
All right, Mr. Stewart, it appears that in all of these cases, you are charged with the same offense, which is a state jail felony, abandoning or endangering a child. A state jail felony does carry a range of punishment of, if you're convicted, to be not less than 6 months or more than 2 years confinement in the Texas Department of Criminal Justice. And you could also receive a fine up to $10,000. The plea agreement appears to be in each one of these cases that upon your plea of guilt, the state is asking the court to review the evidence and to convict you of each one of these offenses and to assess your punishment today at 2 years in the state jail. But they're also asking the court and recommending the court to suspend your sentence and place you on community supervision for 3 years and assessing fines of $500 in each case. And the state's asking the court to allow you to have the evading arrest or detention with a vehicle to be dismissed due to your pleas in these other cases. And you would also be responsible for reimbursement fees in each one of your case, one of them being $535 and the other 3 being $35 each. Is that your understanding of the agreement, Mr. Stewart? All right. Understanding the plea agreement in each case, understanding the range of punishment, Mr. Stewart, how do you plead to abandoning or endangering a child? Are you pleading guilty to these, and are you pleading guilty to each one of these crimes in each one of these cases? And are you pleading guilty to each one of these crimes because you are in fact guilty of committing a crime in each one of these cases? And Mr. Stewart, has anybody threatened, forced, or pressured you to plead guilty? All right, the court does accept the defendant's plea at this time. Mr. Manning, any objection to the admission of the stipulation of evidence? All right, then the stipulation of evidence is admitted in each case respectively. And the court does take judicial notice of the defendant's judicial confession. Is there anything further from the state?
Your Honor, the there is a TPS from all CAs and they have been compliant with all victims. No,
You said there is or is not
it
CPS?
is not.
Is not, okay. Anything further from the defense?
I would just like to point out, Mr. Stewart was pointing to me last month. He came in ready and willing to take responsibility for his actions. And he is the father of these 4 individuals, and he takes his obligation as a father very seriously. You know, I had a conversation about today. He just I told Mr. Stewart, I don't see many men like him come through with the focus on doing what's right, they come into their actions. So I am confident that Mr. Stewart will be able to successfully complete probation, and all the while teach his children that they right wrong as this.
Okay. I appreciate that, Mr. Manning. In reviewing the stipulation of evidence, I I have a concern about factual sufficiency to meet legal sufficiency. In the language, it just indicates that he was driving in a pursuit and that he had his children in the car during the pursuit. It doesn't say anything about the a dangerous act or abandoning or anything of that nature. Can you address that for the court? Because I'm not sure that on a appellate review that this would be sufficient to convict him of this offense.
Yes, sir. I can go in and supplement a little bit more.
And I'm saying that if there was something in here that he was driving in a manner that was dangerous, I think that would be sufficient. But right now, it just doesn't say that. Sure. So let me do this. Let me return the stipulation to you, Mr. Manning, and then you and Mr. Hartwell get together. And if y'all want to write that in there, show Mr. Stewart and have that discussion, and initial those. Let's see. It's Chicago. I got Chicago COVID. I'm just kidding. I don't think I got Chicago. I probably got St. Louis. I'll have this question. Elliot had it on in Chicago, and everyone else got it. Here, let's give this to Mr. Stewart. There's hang on, there's three more I've got to give you. Actually, that may be the only one. That's the one. Here it is. Here's one. Mr. Stewart, did they give you a bill of cost at all? Did you get a printout showing like all your fees? You do? You have that? You sure? Excellent. Okay, good. Very much. Wanted to make sure you got a copy. Yes, please.
Mr. Hotwell, section for the cases, but no, hold on.
You already got it. Thank you, sir. All right, based on the court's review of the revised stipulation of evidence, court finds that there is sufficient evidence to convict Mr. Stewart of each of these offenses. The court will follow the plea agreement and the recommendation of the state today. The court, in each case, based on the evidence, hereby convicts Andre Stewart Jr. of abandoning or endangering a child. The court, a state jail felony. The court assesses punishment pursuant to the plea agreement in each case at 2 years confinement in the state jail division of TDC. The court suspends the sentence and places Mr. Stewart on 3 years of community supervision, orders him to pay a $500 fine in each case. Furthermore, the court is ordering a court cost of $290 in each case. The court does dismiss cause number CR 24-114, evading arrest or detention with a vehicle. The court assesses reimbursement fees and cause number CR 24-115 at $535. And in the remaining cases, the court assesses reimbursement fees of $35. All right, Mr. Stewart. I commend you on taking responsibility for your actions and coming in here as to what Mr. Manning said. I do appreciate that. There's a lot of people that would not do that, right? So you're be commended on that. I can only assume that due to the type of sentence that you're receiving, that the act was pretty dangerous. I understand what was written. I don't know all of the details, but based on what I see here, it was probably pretty serious. So I can only imagine that it really risked the lives of your children. And so let me tell you that you're very lucky today. You're very lucky. You may not feel lucky, but I guarantee you when you walk out of that door and you get to go home and see your kids that were in that car, and you're not visiting them at the graveyard and not going to sleep thinking about them and what could have happened had you done something that was unintentional, but nevertheless killed one of them. That's a life sentence. There's no sentence on this earth. There's no sentence a court could give you if you do something to hurt your child and that child loses their life. So the fact that you're here taking responsibility, I appreciate that. I commend you on that. This is difficult to deal with. Probation is going to be difficult to deal with. Complying may be difficult to deal with, but keep your head up, because when you walk out, I'm assuming your kids are still involved in your life. Is that correct? So when you walk out, and the moment you feel like, wow, I really screwed up, I've got this thing hanging over my head, life sucks, I want you to stop and think about, could be a lot worse. Could be a lot worse. You could be facing a life without one of your children. You could be facing a life with a criminally negligent homicide or a manslaughter charge, which would pale in comparison to the loss of a child. So I want you to just keep that in perspective and let that be the incentive that you use to soldier through and make sure that you comply with all of your conditions, even when it's hard, even when you don't want to know that, hey, yeah, you screwed up, but it could have been a lot worse, and you have an opportunity to get out of it now. So if you'll keep that in perspective in everything that you do, it'll help get you through. Okay. All right, Mr. Stewart, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you come up here to be fingerprinted, and then the probation officers will give you information about what's next. May have missed something in there because there's a lot, but I think I saw it there. Yes. Is this Mr. Molina? Yes. Mr. Molina, come on up, sir. Take your time, don't rush. This is cause number CR 24-27, State of Texas, versus Jose Angel Molina. All right, Mr. Molina, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you, sir. You can lower your hand. All right, Mr. Molina, your name is Jose Angel Molina, is that correct? Mr. Molina, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
And have you ever been diagnosed with a mental condition? In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work that he's done for you? Do you have any questions about your plea agreement and the paperwork you signed today?
Okay.
Mr. Manning, do you believe Mr. Molina to be competent, and if so, that he understands his rights and the advantages and disadvantages of a deferred adjudication plea? All right, Mr. Molina, you are indicted with a third-degree felony offense of failure to comply with sex offender's duty to register for life annually. A third-degree felony carries a potential range of punishment of not less than 2 years in prison or more than 10 years in prison, and also a fine which cannot exceed $10,000. I see the plea agreement in this case is the state's recommending upon review of the evidence that the court consider the evidence, but not convict you of this offense, rather to place you on deferred community supervision for 6 years. They're asking the court to assess a $1,000 fine, $290 in court costs, and $535 in reimbursement fees. Mr. Molina, is that your understanding of the plea agreement? All right, understanding the plea agreement and the range of punishment, Mr. Molina, how do you plead to that offense? Are you pleading guilty to that crime because you are guilty of committing that crime? And Mr. Molina, has anyone threatened, forced, or pressured you to plead guilty? All right, the court does accept the defendant's plea of guilt at this time. Mr. Manning, any objection to the stipulation of evidence?
No, okay.
All right, stipulation of evidence is admitted, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state? From the defense? All right, court will review the evidence. All right, the court finds that there is sufficient evidence to convict the defendant. The court will follow the plea agreement and recommendation of the state. Court hereby defers a finding of guilt on the third-degree felony offense of failure to comply with sex offenders' duty to register for life annually. Court places Mr. Molina on community supervision for a period of 6 years, orders him to pay a $1,000 fine, $290 court cost, $535 in reimbursement fees. All right, Mr. Molina, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted with Deputy Martinez, and then the probation officers will give you more information about what's next. Hey, Todd, will you make sure, I don't know if he has a copy of this, his bill of costs, but if he doesn't, I need to make sure that he gets a copy of it, and he can have that copy. If he doesn't, well, ask him, if he may already have one.
Yeah.
You do? Okay. All right, excellent. Here, then we'll throw that on the back of this. There we go. Hold that with the judgment. Good to go. Right, Deputy Martinez, if you will go call the names of the individuals who are not here, those are Erica Ford and Robert Campbell. If you'll go call those names loudly, distinctly, 3 times in the courthouse. Thank you, sir. All right, the court having called the names Robert Baker Campbell and Eric Renee Ford, they were not present at 9 a.m., nor are they present at this time. The court has had their names called loudly, distinctly 3 times in the courthouse with no response. The court hereby issues judgment nisi, or court hereby issues a judgment nisi in Mr. Campbell's case and alias capias, and then the court issues a capias on the personal bond of Erica Ford. All right, I believe that concludes our morning criminal docket. You agree, Ms. Abraham? You agree? You do agree? All right, since Ms. Abraham agrees, then we're gonna stand in recess and until 1:30. Is that fine, Mr. Abraham? 1:30. Ms. Abraham says 1:30, so we'll be back at 1:30. If she changes her mind, I'll let everyone know.